Welcome to our YouTube video series on business partnerships. My name is Christopher Neufeld of Neufeld Legal. And in this particular video, we will be looking at the distinctions as between a joint venture and a partnership, using the very extensive legal analysis of Madam Justice Nixon in the Alberta Court of King's Bench decision of Woronuk versus Woronuk. In determining whether the parties formed a joint venture or partnership, it is necessary to first consider the concepts of joint ventures and partnerships, and specifically what they are in law. The law of joint ventures and partnerships. What is a joint venture? A joint venture is not itself a legal entity capable of entering into a contract. It takes one of three forms. 1. A corporate joint venture, where a separate company is set up for the joint venture. 2. A partnership among joint venture participants. Or 3. A contractual joint venture where parties proceed with a joint venture based upon agreement. And this is based upon Barry J. Ryder and Melanie A. Schishler's Joint Ventures Legal Business Perspectives. Joint venture relationships are governed by contract between the joint venture participants, whether that is in the form of establishing a corporation to carry out the joint venture, joining together as partners, or agreeing contractually on how the parties will operate the joint venture. They will be subject to the applicable business, corporations, or partnership statutes. In its report on joint ventures in May 2012, the Alberta Law Reform Institute defines joint ventures as, quote, the relationship that subsists between persons who carry on, in common and with a view to profit, a business venture established by contract for a discrete project or undertaking, or for a series of discrete business projects or undertakings. In Central Mortgage and House Corp. Versus Graham, Justice Jones described the factors present in a joint venture, citing Williston on contracts on his decision. Besides the requirement that a joint venture must have a contractual basis, the courts have laid down certain additional requisites deemed essential for the existence of a joint venture. Although its existence depends on the facts and circumstances of each particular case, and while no definite rules have been promulgated which will apply generally to all situations, the decisions are in substantial agreement that the following factors must be present. A contribution by the parties of money, property, effort, knowledge, skill, or other asset of a common undertaking. B, a joint property interest in the subject matter of the venture. C, a right of mutual control or management of the enterprise. D, expectation of profit or the presence of adventure, as it is sometimes called. E, a right to participate in the profits. F, most usually a limitation of the objective to a single undertaking or a ad hoc enterprise. Graham has been cited with approval in a number of other decisions, including by the Alberta Court in Volks Construction Limited versus Westlock Foods Limited and Penbro Holdings Limited versus Demchuk, and by numerous provincial appellate courts. In Volks, while the Court of Appeals did not mention Graham, they considered the facts of the specific case. They disagreed with the trial judge that mutual control and management of the enterprise was a key consideration in determining that there was no partnership, and instead relied upon the statutory definition of partnership in the Partnership Act to conclude that there was a partnership. Control was not necessary for the existence of a partnership where profits were to be shared. The parties spoke to each other as partners, and there was a right to consultation and involvement in the business. However, Graham is not without criticism. One legal scholar has asked whether the factors of a joint venture, as cited by Justice Jones in the Graham decision, quote, perfectly describe a model partnership, end quote. Robert Flanagan, the legal status of the joint venture. Flanagan goes on to state, the Graham decision is a profoundly flawed exercise in judicial innovation. The analysis of the distinction between partnerships and joint ventures did not extend beyond the quotation from American secondary sources. In the end, nothing in the decision justifies acceptance of the joint venture claim. Nevertheless, it is the key judgment in Canada. A large part of the subsequent Canadian jurisprudence on the topic is derived from or dependent on the decision. Notwithstanding academic criticism, Madam Justice Nixon accepted it as authority on the characteristics of joint ventures in Canada. These characteristics are reiterated and discussed hereafter in several cases that discuss partnership as well. What is a partnership? Under the Partnership Act, partnership means the relationship that subsists between persons carrying on a business in common with a view to profit. Section 1G. A corporation is not a partnership. Partnership Act, Section 3. A person may be an individual or a corporation. In its Joint Ventures Report, the Alberta Law Reform Institute notes, as the status of partners is imposed by statute, the test for determining whether a partnership exists is objective, and the weight of authority is to the effect that the parties cannot contract out of that status by a term in their contract. In Section 4 of the Partnership Act, guidance is provided for determining the existence of a partnership, the relevant experts of which include 4. In determining whether a partnership does or does not exist, regard shall be had to the following rules. B. The sharing of gross returns that does not of itself create a partnership. Whether the person shares the returns have or have not a joint or common right or interest in property from which or from the use of which the returns are derived. C. The receipt by a person of a share of the profits of a business is proof, in the absence of evidence to the contrary, that the person is a partner in the business, but the receipt of the share or of a payment contingent on or varying with the profits of the business does not of itself make the person receiving the share or payment a partner in the business, and in particular, I. The receipt by a person of a debt or other liquidated amount by installments or otherwise out of the accruing profits of a business does not of itself make that person a partner in the business or liable as a partner. 2i. A contract for the remuneration of a servant or agent of a person engaged in a business by a share of the profits of the business does not of itself make the servant or agent a partner in the business or liable as a partner. The Supreme Court of Canada provides guidance on whether a relationship is a partnership in Continental Bank of Canada versus the Crown, setting out, quote, 3 essential ingredients. 1, a business. 2, carried on in common. And 3, with a view of profit, end quote. In dissent, Justice Bastarache makes the following statements, with which the majority agreed. The existence of a partnership is dependent on the facts and circumstances of each particular case. It is also determined by what the parties actually intended. As stated in Lindley and Banks on partnership, quote, in determining the existence of a partnership, regard must be paid to the true contract and intention of the parties as appearing from the whole facts of the case, end quote. The Partnership Act does not set out the criteria for determining when a partnership exists. But since most of the case law dealing with the partnerships results from disputes where one of the parties claims that a partnership does not exist, a number of criteria that indicate the existence of a partnership have been judicially recognized. The indicia of a partnership include the contribution by the parties of money, property, effort, knowledge, skill, or other assets to a common undertaking, a joint property interest in the subject matter of the adventure, the sharing of profits and losses, a mutual right of control or management of the enterprise, the filing of income tax returns as a partnership and joint bank accounts. See A.R. Manzer, A Practical Guide to Canadian Partnership Law. In Kulak versus A.G. Clark Holdings Limited, Justice Vervale discusses the elements of a partnership. The parties agree the three essential elements of a partnership are: 1, a business; 2, carried on in common; 3, with a view to profit. The Act provides guidance as what factors may or not be relevant in determining whether a partnership exists. In Bachman versus the Crown, the Supreme Court discussed the essential ingredients of partnership. With respect to whether a business is carried on in common, the court stated, in determining whether a business is carried on in common, it should be kept in mind that partnerships arise out of contract. The common purpose required for establishing a partnership will usually exist where the parties entered into a valid partnership agreement, setting out their respective rights and obligations as partners. As was noted in Continental Bank, a recognition of the authority of any partner to bind the partnership is relevant, but the fact that the management of a partnership rests with a single partner does not mandate the conclusion that the business was not carried out in common. This is confirmed in Lindley and Banks on Partnership, where it is pointed out that one or more parties may in fact run the business on behalf of themselves and the others without jeopardizing the legal status of the arrangement. It may be relevant that the parties held themselves out to third parties as partners, but it is also relevant that the parties did not hold themselves out to third parties as being partners. Other evidence consistent with an intention to carry on business in common includes the contribution of skill, knowledge, or assets to a common undertaking, a joint property interest in the subject matter of the adventure, the sharing of profits and losses, the filing of income tax returns as a partnership, financial statements and joint bank accounts, as well as correspondence with third parties. See the case of Continental Bank. As to the approach to determine whether a partnership exists, the court stated, as adopted in Continental Bank and stated in Lindley and Banks on Partnership, to determine the existence of a partnership, regard must be paid to the true contract and intention of the parties as appearing from the whole facts of the case. In other words, to ascertain the existence of partnership, the courts must inquire into whether the objective documentary evidence and the surrounding facts, including what the parties actually did, are consistent with their subjective intention to carry on business in common with a view to profit. Courts must be pragmatic in their approach to the three essential ingredients of partnership. Whether a partnership has established in a particular case will depend on an analysis and weighing of the relevant factors in the context of all surrounding circumstances. That the alleged partnership must be considered in totality of the circumstances prevents the mechanical application of a checklist or a test with more precisely defined parameters. The indicia of a partnership, as set out in case law, are thoroughly discussed in the decision of Justice Tilleman in Elbow River Marketing Limited Partnership versus Canada Fuels Inc. Justice Tilleman summarizes the indicia of a partnership in the context of a summary judgment motion and discusses the meaning of each of the three essential ingredients from Continental, including 1, a business; 2, carrying on in common; 3, with a view to a profit. He notes, some factors are more important than others. One of the strongest indicia of partnership has always been the sharing of profits. Though since the 1860 case of Cox versus Hickman, it is no longer completely determinative. Cox versus Hickman, cited by Sproul versus McConnell, sharing of profits is still, however, proof of partnership in the absence of evidence to the contrary. Partnership Act, Section 4C, Paragraph C goes on to list exceptions to the presumptive rule that sharing profits proves partnership. The exceptions relate to debtor-creditor relationships, employment agency relationships, and other situations that equally do not apply here. I'm quick to point out that the best evidence of an agreement to carry on business together is a written partnership agreement. A written agreement is not compulsory, however, nor is it required that the parties have even expressed their intention to form the partnership. The Newfoundland and Labrador Court of Appeal considered the quotation from Bastorak of Continental, along with an extra from Manzer, and observed that neither indicates that it is necessary to find a specifically expressed intention or a written agreement to form a partnership in order to find that one has been established. That intention and agreement can be inferred from the conduct of the parties on consideration of all of the evidence. Green versus Harnham. When a court is looking to the conduct of the parties to determine if a partnership agreement may be inferred, the course of dealings as between the parties and their dealings with others will be reasonably determinative as to whether there is a partnership. Manzer. In Blue Line Hockey Acquisition Company versus Orca Bay Hockey Limited Partnership, the British Columbia Supreme Court considered whether the relationship between three people was a non-partnership joint venture or a partnership, and concluded it was neither. The trial judge in Blue Line reviewed the requirements for a partnership, noting that while the statute does not mention contract, the existence of a contractual foundation of partnership is essential. Further, whether oral or written, there must be a complete agreement before a partnership will be found to exist. The contract underlying a partnership must meet the following prerequisites of a contract. A. An offer containing all the essential terms and an acceptance of the offer, that is, a meeting of the minds or consensus ad item. B. Certainty of agreed terms. C. Consideration. And D. The intention to create legal relations. The court considered the statutory ingredients of partnership, including carrying on business in common with a view to profit. Blue Line also included a discussion of the characteristics of joint venture. Relying on the British Columbia Court of Appeals decision in Canlin Investment Corp. versus Getling, the court noted, the ingredients of a joint venture are as follows. A. As in the case with partnerships, the joint venture must have a contractual basis. And B. There must be, one little I, a contribution of money, property, effort, knowledge, or other asset to a common undertaking. 2 little I, a joint property interest in the subject matter of the venture, which is usually a single or ad hoc undertaking. 3 little I, a right of mutual control or management of the venture. And 4 little I, an expectation of profit and the right to participate in the profits. In conclusion, the trial judge in Blue Line described the fundamental requirements in common of both partnerships and joint ventures as follows. In summary, while the constituent ingredients of a partnership differ slightly from that of a joint venture, both require as their foundation a binding contract among the partners or joint venturers, which contains all the essential terms of agreements between the parties. The British Columbia Court of Appeal approved the trial judge's legal analysis, reiterating that a partnership results from a contract between the partners and that a joint venture also has contractual underpinnings. The notion that sharing in profits is not necessarily determinative of a partnership is supported by Section 4, sub C, sub 2 little I of the Partnership Act, excerpted above, which provides that the receipt of profits of a business in some circumstances does not itself make the recipient a partner in the business. The Supreme Court of Canada discussed the approach to be taken to determine whether a partnership exists in Bachman versus the Crown. As adopted in Continental Bank and stated in Lindley versus and Banks on partnership, in determining the existence of a partnership, regard must be paid to the true contract intention of the parties as appearing from the whole facts of the case. In other words, to ascertain the existence of a partnership, the courts must inquire into whether the objective, documentary evidence and surrounding facts, including what the parties actually did, are consistent with a subjective intention to carry on business in common with a view to profit. Courts must be pragmatic in their approach of the 3 essential ingredients of partnership. Whether a partnership has been established in a particular case will depend on analysis and weighing of the relevant factors in the context of all the surrounding circumstances. That the alleged partnership must be considered in the totality of circumstances prevents the mechanical application of a checklist or a test that more precisely defined parameters. A partnership, like a joint venture, is based on the existence of a contract among the parties. Unlike a joint venture, however, a partnership is a legal entity that owns assets and has liabilities. The cases and commentary examining joint ventures typically focus on whether the relationship among the parties creates a partnership. The existence of a partnership affects the parties' obligations to each other and the remedies available for breach of those obligations. A partnership creates fiduciary obligations. Thank you.